When ex-Chadian President Hissène Habré was sentenced to life imprisonment in 2016 for war crimes, crimes against humanity, and torture, it was a double victory. The victory of a struggle for justice that has been fought by the victims and their loved ones for 25 years. And also the victory of a legal process intended to better respond to certain crimes that are so serious that they pose a threat to the entire international community. This was the first time an African tribunal had tried a former head of state for international crimes. The trial was possible thanks to the combined efforts of Senegal, the African Union, and Belgium in the name of universal jurisdiction. This is an exception. Usually, according to the principles of sovereignty, a state's jurisdiction is based on the principles of territoriality and nationality. In other words, a state may initiate legal proceedings for crimes committed on its territory, or if the alleged perpetrator or victim of a crime committed outside of its territory is a national of that country. There are, however, situations where it is possible to deviate from these rules. This is where universal jurisdiction comes into play. What is universal jurisdiction? According to its principle, a state can try perpetrators of certain crimes, regardless of the location of the crime or the nationality of the perpetrator or the victim. Universal jurisdiction applies to crimes of such magnitude that they violate the principles of humanity and thus affect us all. The aim is to prevent the perpetrators from evading justice if they have escaped domestic prosecution. After the Second World War, this exception was created by the 4 Geneva Conventions of 1949 and their additional protocols, international treaties which define the basic rules of warfare, and international humanitarian law. Universal jurisdiction is established to prosecute war crimes and to fight against impunity beyond national borders. The principle was then consolidated by other conventions, such as the 1984 Convention Against Torture and the 1998 Rome Statute. It has thereby been extended to include other crimes such as torture, genocide, and crimes against humanity. For certain of these crimes, such as torture, these conventions oblige the signatory states to act if the alleged perpetrator of the crime is on their territory. According to the principle of haute dedire haute judiciaire, they must either extradite perpetrators of these crimes or prosecute and try them themselves. In 2005, this principle enabled Belgium to ask Senegal to extradite Hissène Habré, the former president of Chad, on behalf of the victims. Under pressure from the International Court of Justice and with the support of the African Union, Senegal decided to prosecute Habré itself. In 2016, Habré was found guilty of crimes against humanity, rapes, executions, slavery, and kidnapping. How did Belgium become a major player in universal jurisdiction? In 1993, Belgium adopted a law giving Belgian courts universal jurisdiction to try serious crimes under humanitarian law. This law initially focused on war crimes and allows prosecution even if a person is not on Belgian territory. In 1998, Belgium launched an investigation under this law against Chilean General Pinochet for misdeeds committed by his regime. Since 1999, a new Belgian law has explicitly widened the scope of application to crimes against humanity and genocide. The result has been a deluge of complaints sent to the Belgian prosecutor's office by victims from all over the world. These complaints mainly regarded Rwandan genocide suspects, but also concerned heads of state such as Saddam Hussein, Fidel Castro, Ariel Sharon, or George Bush Sr. for alleged crimes committed under their rule. Several countries, including the United States of America, felt threatened by these initiatives and started putting some pressure on Belgium to revise this law. After a few years, in 2003, the 1993 law was repealed and the Belgian Criminal Code amended. Yet Belgium still exercises a restricted form of universal jurisdiction. Fabien Naretse, for example, was the first person brought before a Belgian court to be prosecuted for and found guilty of the crime of genocide committed in Rwanda in 1994. Because one of the victims was of Belgian nationality, the case had a direct link to Belgium. What is the role of international institutions? International institutions such as the ad hoc tribunals or the International Criminal Court, working alongside national jurisdictions, are powerful tools in the fight against impunity. The creation of the International Criminal Tribunal for the former Yugoslavia in 1993 and for Rwanda in 1994 highlights the added value of a permanent institution with a broader scope of action. The Rome Statute established the International Criminal Court in The Hague in 2002. The ICC is able to prosecute genocide, war crimes, crimes against humanity, and since 2010, also the crime of aggression. It can initiate proceedings for such crimes committed by nationals of or on the territory of states that have been ratified in the Rome Statute, as is now the case for over 120 countries. The UN Security Council could also refer cases to the court involving states which have not ratified the statute. Burundi and the Philippines have left the International Criminal Court because they question its impartiality. Certain countries, such as the United States and Russia, never ratified the Rome Statute. Others, such as China, have never recognized the court's jurisdiction. Universal jurisdiction, therefore, has an important part to play in bridging this gap. What future does universal jurisdiction hold? In recent years, we've seen a global increase in cases based on universal jurisdiction. In 2019, prosecutions based on this principle were ongoing in 16 countries, a new record. In 2020, another 18 cases were opened. Among the most notable cases are the proceedings against Syrians Anwar Raslan and Iyad Al-Gharib, and that against the Congolese Roger Lambala in France. Actions were taken following a complaint filed with the Argentine courts regarding the allegations of genocide carried out against the Rohingya people of Myanmar. The facts are clear. Universal jurisdiction is one of the best legal tools at our disposal to fight impunity for the most heinous crimes. Such initiatives are vital and send clear messages to the perpetrators of these crimes. There is no escaping your actions, and you will be held accountable.